All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Parmer, and I'm the director of the statewide training initiative with Florida Legal Services. We're excited to have you join us today for navigating today's immigration system, policy shifts, legal updates, and removal defense. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive a copy of this recording and the link to the materials from Zoom within about 24 hours. I'll also be posting it on YouTube, so you can subscribe to our channel, or you can just access our YouTube channel, and you can access the materials and the recording once we post it. If you know of somebody that was unable to register, make sure to let them know that it's been posted so they can access it afterwards. The training was approved by the Florida Bar for 1.5 General CLE credits and 1.5 Immigration and Nationality law certification credits. I'll announce the CLE code towards the end of the webinar. I'll also add the CLE code in the chat, and I will also add the CLE code information in the YouTube description and in the email from Zoom as well. Closed captions are enabled for anybody who needs them, so if you're having any issues with accessibility, do not hesitate to reach out. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. So if you're not familiar with PILS, I'm going to drop a lot of information about PILS into the chat. There is one particular work group that you should look into if you're interested in immigration work. We have an immigration work group led by DJ Neary, and I know Leah might be here. I don't know if you want to say hi in the chat, but they meet monthly. This webinar is happening because of that specific work group. I know Adriana spoke to them a few months ago, and we basically were like, yeah, we need to do this as a webinar to make sure that we share this with the broader public. So it's a great work group to join. If you're not familiar with PILS, as I said, I'll drop the information in the chat. Membership is currently $55 a year, and if you're a law student, it's free. So if you're in the private bar, it's a great way to connect with like like-minded people and the legal aid community as well, and you have access to a bunch of CLEs. So with that said, I think the final piece of housekeeping announcements are questions and answers. With this type of topic, I know we always get a lot of questions. So if you have questions, please use either the Q&A feature if you can. It's ideal if you use the Q&A feature. If you drop questions into the chat, I will probably ask you if you can drop it into the Q&A as well. What we'll do is if the questions are answered as we go, I'll mark them as answered. But we will try to hold those questions and address those questions towards the end. But as the questions come in, drop them into the Q&A feature, and we'll make sure all of those are addressed towards the end. So with that said, I want to go ahead and introduce our speakers today. So our first speaker is Adriana Dinis with the Immigration Law Group of Florida. Adriana is a shareholder and co-owner of Immigration Law Group of Florida. She began her legal career representing undocumented children through the GLS Child Project at Gulf Coast Legal Services, where her work was recognized as first runner-up for the Paul Doyle Children's Advocacy Award. Adriana has extensive experience representing children in immigration proceedings and has trained attorneys, law enforcement, and community organizations statewide on immigration benefits for children. Our other speaker is Marisol Zequeira with Americans for Immigrant Justice. Marisol Zequeira is the director of the Pro Bono program at Americans for Immigrant Justice. Raised in Madrid after being born in Miami, she has devoted her legal career to immigration and refugee advocacy, beginning with legalization work under the Immigration Reform Act of 1986. Her experience includes refugee resettlement in Haiti, leadership roles with clinic, supervision of legal services programs across South Florida, and many years in private practice. She brings decades of experience serving immigrant communities and strengthening pro bono advocacy. So thank you to both of our speakers for joining us today in this very important topic. So without further ado, I'll pass it over to our speakers. Adriana and Marisol, the floor is yours.
Thank you.
Thank you. Thank you so much for having us. I know that Marisol and I are happy to answer any questions that we have today, but if there's something pressing that we didn't cover, you're always feel free to email us and we can do our best, if we don't know it, to get you definitely the answer. So I always like to start with explaining what immigration really means, because I get calls still, people saying, oh, INS, but INS doesn't exist. anymore, even though a lot of our statutes in Florida and other states still say INS. So now immigration, these are the main agencies that people deal with. The United States Citizenship and Immigration Services is our application center. It used to not have enforcement powers, really. It was not like the ICE police that we see, but you'll see in the next slide that that's kind of changed recently. Then, of course, the one that everybody knows is ICE, U.S. Customs, Immigration and Customs Enforcement, and that's, who goes around detaining people. Sometimes we work with HSI, which is Homeland Security Investigations. And then we have CBP, which is U.S. Customs and Border Protection. They're predominantly in our borders and airports, any port of entry, but you'll see that their jurisdiction pretty much covers the entire Florida because it expands within 300 miles of our border. And then our immigration courts, which are not part of the judicial branch, they're under the executive. It's the Executive Office for Immigration Review. You'll probably hear a little later on what problems that causes for us as attorneys. So like I mentioned, Border Patrol, this is their jurisdiction. And in Florida, in our area, in the Tampa Bay area, we see them a lot on like the highway between Tampa and Gainesville area, just, pulling over people. And this is why they have jurisdiction throughout the state of Florida. It's not just, cruise ships and airports and things like that. So like I mentioned, USCIS did not have really any enforcement powers before. It's just where people would go do their, their application. They're applying for, citizenship or maybe a spouse that's filing for them. But as of last year, they were given enforcement authority. And we're still kind of trying to figure out what this means. It's not all USCIS officers. They're supposed to, have a certain, amount of them that they're training to, execute warrants and arrest individuals and be able to carry firearms. I hope that doesn't mean that I'm going to be sitting in an interview and the actual interviewing officer will be arresting my client, but we just really don't know how this is going to play out. It's a wait and see approach. We are having people detained at interviews, but it's by ICE still. I have not heard of a USCIS officer actually detaining an individual at their office. And just some changes. Our immigration system has always had kind of discretion, right? We don't have the manpower to go after everybody. And also another thing that usually we had guidelines as to where enforcement can be carried out. We didn't want enforcement at hospitals or churches or schools because, those were determined to be protected areas where people should feel safe. But unfortunately, as of January of last year, those areas are no longer considered protective areas at all. So now they're supposed to use the common sense approach in these areas, whatever that means, because it's not really defined. So obviously this is, for me personally, as an attorney, I used to do a lot of know your rights at like churches. And now I'm really kind of hesitant because I don't want, an event where I am going to be there and a bunch of people are going to be there. And then it's just kind of easy pickings for ICE. So we now are really moving a lot to Zoom because of these protected areas memos. So some places, obviously, long distance buses. Greyhound used to allow officers to get on their buses and ask for documentation. I haven't heard that. They said last year, I think it was last year or the year before, that they were going to stop that. And so I haven't heard it as much as I used to. But one of the big things that I really wanted to kind of hammer in is that if you have a client with a pending immigration benefit, so they don't have a green card, they're not a US citizen, I would highly advise that person not to fly at all within the United States. TSA is sharing flight manifests with immigration, and they are detaining people at airports. This could be somebody that has, like a marriage-based green card interview pending. We've seen a lot of those, right? They're going on their honeymoon after they get married. They have a pending green card. They have a Florida ID and a Florida, driver's license. They think everything's okay flying with these documents, and it is not, because they're still not in immigration status. So I would just be very, very careful with having anybody travel on even inside the United States in flights. Obviously, jails, probation offices. We see it a lot with DUIs where once they start probation, immigration will come to the probation office to pick up people. Obviously, federal buildings, we'll talk a little bit more about that, but I'm sure you guys saw in the news that people were showing up to the immigration hearings and were getting detained. And then in our local courts, at least in the area of the Tampa Bay area, I haven't heard it as much as during the first Trump administration, where somebody would be at a like no valid driver's license hearing, and then afterwards immigration will pick them up. I haven't heard that as much, but Marisol will talk a little bit about ICE holds and stuff like that. And I do think that that is definitely ramping up and how they're picking up people at the local jails. But I haven't heard it as much personally in our local courts. And then obviously we just talked about USCIS, that people are being detained at their interviews, which makes no sense because a lot of these are pretty clear-cut cases of people that qualify for their green card. So there's really no reason to detain them because then they're going to be detained and get their hearing before a judge and get their green card that way. So it's just kind of like not necessary, really. And then another thing, like I mentioned in the beginning, is that we can't go after everybody. So DHS, the Department of Homeland Security, which includes CBP and ICE and all the other agencies we talked about, has always had like discretion who they're going to go after. So it's always, not always, but usually it's been like national security risks, people with crimes, public safety, things like that. But there is right now, everybody is a priority. And like I said before, this includes people that enter lawfully, that have like a pending asylum case, or people that maybe they entered with a tourist visa a long time ago and they have a pending marriage-based case. Pending means nothing. And this also includes we've started in the listservs yesterday, I heard of a couple people that have DACA, that have had DACA for a while, that they're detaining as well. So no one is safe. Everybody right now is a priority, is what we're seeing. And then I think that's where, Marisol, you take it, right?
Yes. Again, good afternoon, everyone. I think we can't underscore enough that everybody is a priority right now. However, there has been some changes with this administration as to who is subject to a certain type of removal, which is called expedited removal, that used to be exclusively for people who were entering through the border, who was within that 100-mile border limit where Customs and Border Protection had operated, and 14 days. You have to prove that you were, if you were less than 14 days from the date of your entry. Everybody else we used to understand were not subject to what we call expedited removal. And this is important because this has changed significantly since this administration took office. One of the things that we're seeing is that expedited removal is being applied to people, not just people who enter through the border and couldn't prove that they were here at least 2 years physically, and who were not admitted or paroled. It's being applied to people who have been in the United States under a status that we call entry without inspection. They were not caught at the border, they were not inspected or paroled, and now it's being applied to some of these individuals as well. If you were determined to be inadmissible, which most people were under 212A6C, which is fraud or misrepresentation, you had a charge, for example, that you provided a fraudulent document, or 212A7, which is basically coming in without valid documentation, you are possibly considered subject to expedited removal. And what's also important is it is your burden to prove that you have been here physically present more than 2 years. And so basically what we're seeing, and you have 2 cases here that are cases where nonprofits and legal services providers are challenging this interpretation of who is subject to expedited removal. What we're seeing is that this administration is basically casting a very wide net and an interpretation that goes against 30 years of understanding of what was expedited removal and who was subject to it.
Marisol, just for people that might not know what expedited removal, can you just briefly explain?
So expedited removal is basically if you're crossing the border into the United States, allows the immigration enforcement, the immigration officer to basically apprehend you, detain you, and you are only allowed to go before an immigration judge if you can articulate a fear of return, or that your life is going to be in danger under, for example, Convention Against Torture. Those are the only circumstances whereby you would be allowed to go before an immigration judge. Otherwise, you are, as the phrase explains, you're subject to expedited removal, expedited expulsion from the United States. Does that explain like something?
No, that's perfect. Yeah, I just
Okay.
wanted people to
No,
understand that you don't get to see a judge. You're just
you get to see a judge. You go, basically you are not and most people in our communities think that they have an absolute right to go in front of an immigration judge, and that is not the case, especially under expedited removal. But what's important about this new administration's definition of who and understanding of who is subject to expedited removal is that they've expanded that definition significantly. And now, and it also, they're expanding it to people who are in the United States under what we used to, because they enter without inspection, that have numerous equities and possible forms of relief, and yet they're still being subject to expedited removal under this new, more expanded definition of what that means. So in the next, there's also some things that this new administration has done is they've expanded people to include people who are apprehended who cannot show that they've been here at least 2 years. And they're also, like I said, expanded to people who are just basically not being inspected or paroled. Anyway, in the next slide, they basically they have also determined that they are subjecting they're making everybody subject to this new registration requirement, which was an old law from 1940, known as the Alien Registration Act, would basically require that anybody that was over 14 years of age and in the United States for more than 30 days had to register. Willful failure to register comes with it's an offense. It's a misdemeanor offense, and it carries a fine as well, in addition to potentially time in jail. Supposedly failure to show proof of your registration could also carry a fine and 30 days in jail. There's an form, a G325R, that can be completed. It's online, and I don't know about Adriana, but for me, when this came out, many of my clients were calling and saying, do we register? Do we not register? Obviously, this community wants to comply with this new requirement, but the issue with registration with someone who hasn't been identified or does not have an ongoing matter before USCIS or the Executive Office of Immigration Review is that you subject them to, you're putting them in the system so that arguably they can be then detained because obviously they don't have anything in the pipeline. There are certain documentations that I
don't know.
I think we may have lost. I think Marisol
Yeah, I think we
paused.
may have
So
lost Marisol a second. Maybe I can explain what she was about to explain and see if she comes back. There are some documents that automatically show as proof of registration. So if somebody has a green card, an I-94 is usually the little piece of paper that they used to give people when they entered the US in our airports. A border crossing card, notice to appear is the document that people get when they're going to be placed in court, and work permits. So those kind of things are evidence of registration. Registration is something that is also so old that it has not kept up with our immigration laws and new benefits. So, like for instance, we have people doing certain waiver applications that didn't exist back then. And technically, these applications, even though they've been fingerprinted, it doesn't count under the registration regulation as a registered document. But when you go register those clients, they get a notice back from immigration saying you don't need to register because you've already been registered. And so we're still have no idea who actually needs to register, except we know for sure these people that are in the regs, but we're also getting notices for people that have filed certain benefits that don't really qualify as a registration as a registry. But just something to keep in mind, I would just register someone because it could lead to their deportation unless they have a relief pending. And then this gets confused with registry that existed in the 70s for people that had been here for a certain amount of time. They could register and then get their green card if they can show, they've been here for X amount of years. So a lot of people think that a lot of people were excited thinking that this is what this was, but it's not. So just something to keep in mind. I'm thinking Marisol is not correct, Jorge?
So we lost Marisol, but I
Okay.
emailed her with the link. Hopefully she can come back. So
Okay, it's okay. I can keep going. That's totally fine. So like I mentioned before, we're not seeing ICE, or at least I'm not in the Tampa Bay area in our local courts waiting for people in a no valid driver's license, or sometimes we would see them in the injunction hearings last administration. But what I am seeing is an increase in what's called an ICE hold while they are detained in our local jail. So ICE hold is basically a request by immigration to detain the person. Immigration, or to hold the person, not detain the person, wrong legal term. Immigration has 48 hours, not including weekends, which is Saturday, obviously Saturday, Sunday, or holidays to pick up the person. But what's important here is the 48 hours do not begin until the person pays bond, or they're released on their own recognizances, or they served it, it's time served. And what was happening, at least in the Pinellas County jails this started a while ago, is that they weren't letting people pay the bond. They were like, well, he has an ICE hold, so you can't pay the bond. And that's not true. And remember, if they don't pay the bond, then it doesn't, the 40 hours never start. But what I am seeing is people pay the bond and immigration is picking them up within the 48 hours. It's not something before it would kind of be hit or miss whether they're picked up or not, but now they need their numbers of people that they're detaining. So they are picking up people more quickly. An ICE hold is not mandatory. It's just a request from the jail. But in Florida, and we'll talk a little bit about it in a second, all our jails are 287G, which means that they are working with ICE. And so they are detaining people. One thing that I heard at least in the Orlando area is that they are picking the people up when 48 hours is like right before the 48 hours is, then like driving them around Orlando and then like rebooking them so the 48 hours start. So that's something new that I just heard of this week. Also, putting an ICE hold on an individual doesn't really mean that they are going to start deportation proceedings. I think right now it's more likely than not. And it also doesn't mean that the person is going to be deported, right? Some of these people do have relief that they can request in court. So this is another thing I wanted to talk about these slides. A lot of them are very heavy with information, and I just wanted to provide the information so that you guys are welcome to go back and look at the slides. And we're obviously not going to cover everything, but I figured if you have the information, at least you can go back and look at it. Also, anything that's obviously hyperlinked is linked to something that I thought would be useful, like the 287G program. Hyperlink sends you to the website where you can actually go down and see every county in Florida and which model they are using. And that way you can kind of see what's going on in your local area. But a 287G program, which the Florida governor has mandated our agencies to be a part of. It's basically a way to work with ICE, or their ERO, which is their Enforcement and Removal Operations arm. So the jails are obviously usually using the jail enforcement model. But in Florida, we are also seeing like Florida Fish and Wildlife is part of this. In our area, FHP is very heavily involved, especially on I-4, the Division of Alcoholic Beverages, like in tobacco. Like also, I saw last time I checked, I only saw one state attorney, which was ours in the Sixth Judicial Circuit, was part of this model. I don't know what that means. Most university police departments. So depending on the model, some of them is lists like we're going to detain people at our local jails that are not detained, that they're detained for immigration purposes. Some of the models are we're actually like training on officers to be ICE officers. So it just kind of depends on what model it is. But right now, I would say most of our law enforcement are like deputized ICE officers, basically.
If I may, and I'm so sorry. Let me apologize. My laptop died. I basically had to scramble to get to another computer. I am so sorry, and thank you so much, Adriana, for picking it up. If may, I didn't want to interrupt, but I'm in the 19th Judicial Circuit in the Martin County, Treasure Coast area, and what we have seen is an increase in task. They have the task force model. They have actively recruited from other law enforcement agencies, and we see literally swarms of agents from the Florida Highway Patrol, wildlife, everybody, and they have deputized about 15 law enforcement officers from Martin County Sheriff's Office that routinely engage in task force, joint task forces with ICE.
Yeah, and I think the next couple of slides are yours, but I did want to bring up that this program is ripe with problems because then the immigrant community doesn't want to cooperate with the police if they're victims of crimes and things like that. So there is a lot of problems with these models and these programs because it backfires where if you're a victim of a crime or if you need to, testify or whatever, you're not going to because now you're terrified whether you're going to be detained. So I think the next couple of slides might be yours. Yes.
Yeah.
Anything else on this one?
No, just to be on the lookout. There are certain areas that are enforced very much targets for enforcement. I happen to be in an area where that is the case, and we've seen that. I understand Orlando, for example, is definitely going to be, and given that they're also expanding detention beds, they're actively looking to expand their detention facilities in Orlando, as I understand, and Jupiter, Florida. You're going to see a lot more enforcement of this kind, mostly the task force model and the jail enforcement model. We're seeing both, but I believe that depending on where you live geographically, there are targeted areas. I know I live in one. So be on the lookout for that. Those of you who may practice criminal or other types of law practices that cross or deal with this population, you're going to be seeing this a lot and having a lot of questions about this. So as far as how to locate someone if they're detained, which is our next, there's definitely the locator.ice.gov. You can search by what we call an A number. An A number is a 9-digit number that starts with a capital A that every single individual that is it is identified and is processed within ICE or USCIS. That is their the number by which they identify. That's their file number, so to speak. So sometimes if there's the first encounter with immigration, they won't have a name number until immigration processes them and issues what we call a notice to appear, and that will have that A number. That A number can help you locate that person while they're in detention. Many times, so you see how people don't have a file, so you can locate them by their full name and their date of birth and country of origin in these ICE locators. One thing I want to advise people is that it's taken the government at least 48 hours, in my experience, to sometimes put this information on their database. And I've had countless families that are desperate to find out where their loved one is, and it takes them 2 or 3 days to locate them. So just be patient. This is just the way it works. There are examples on your slide as to what alien number looks like. And if not, the other option is the Federal Bureau of Prisons website. Again, it takes them a little while to put these to put this information in their database. So just be aware of that. Also, what we were seeing, at least with Alligator Alcatraz, for example, was that we're taking a little longer because that detention facility is not managed by the federal government. Technically, it's managed by the state of Florida. And so it took them a while to get their ducks in a row and try to and share information. So there were times with I know with clients where there were days where we did not know where this individual was located until they actually put that information in the database. And it's not as accurate as it should be. Make sure that the names are correct, the country of origin is correct, and the date of birth is correct. And if they've had already a file with immigration that showed an AKA, also known as just another identifying name, use that name. Sometimes that's the one under which that you will find this individual in the locator system.
I did want to bring up in our county, in Pinellas County, I think it's the only county I've ever seen this in. Anybody that has an ICE hold at the jail will have a Pinellas County clerk of court federal case that has their A number on it. It's a weird thing that I don't know why Pinellas does it, but if you have a Pinellas client that was in jail, you'll see like a case and it has the A number on it as the case number, I think.
So the other way to, I mean, if your client is in proceedings before the Executive Office of Immigration Review, which Adriana explained, it's the branch within the Department of Homeland Security. Well, it's part of the Department of Justice, but it's under the Attorney General, is the court that processes and determines eligibility for certain benefits for people who are placed what we call in proceedings. This is not an Article 3 type of court. These are administrative judges who are basically are hired and fired at the will of the Attorney General. And what we're seeing over and over is that they are lacking independence through and through. So don't confuse this with federal court in general, or even with your civil court judges who have a certain degree of independence. The EOIR, immigration judges, EOIR judges are under the Department of Justice, and they get their marching orders from the Attorney General down. So if you want to, there's a number that in the old days when we didn't have an ECAS system, we just called this 800 number, and it gives you some prompts. And you can you have the automated system is in English and Spanish. I think this, if you press number 2, it's Spanish. You put in the A number. It's very, very important that you always have this A number to locate your client, or to locate information about your client. And it's going to tell you the history, that individual's history, whether or not they've ever been in removal proceedings, whether they have a hearing date. And it'll tell you the date, the location of the court, the time where that hearing is, and the kind of hearing. Within immigration court, we have 2 types of hearings. We have something called a master calendar hearing. It's akin to a docket sounding in civil court, or, you know, in criminal court, I don't recall what it's called, but it's just your first appearance, so to speak, where you actually, the judge reads to you the charges, the immigration charges. You either accept or deny. There's some factual allegations, and then the judge, you ask for whatever relief you have before that body. That's a master calendar hearing. The other one would be an individual hearing, which means it is a merits hearing. It is an evidentiary hearing where the burden is on the applicant, of course, and you are at that point presenting your case before an immigration judge, and the judge determines whether or not you're eligible for that form of relief. In that system, it'll also tell you if that person has an order of removal, if their proceedings were terminated, if there was any relief granted, if there was an administrative closure of that case, so that you have some more information at a glance about that person. And it also, of course, will tell you if there's an outstanding deportation order or an appeal pending. Can you go into the next one?
I think this is me now.
Okay.
Yeah. If you go on the EOIR, either the phone number or the website, and it just says the case is blocked, sometimes you'll see that. We used to do that a lot with our victims of domestic violence. We would ask the court to block their information because we didn't want the abusers checking on it. So the only way to get any information is to contact the court, which is currently a nightmare. Nobody picks up the
Yes.
phone. Nobody
Nobody
picks up the
does.
phone
No
in
judicial
immigration.
assistant picks up the phone. It's
Yeah,
impossible.
nobody picks up the phone in immigration court. You like have to drive. Our closest court in the Tampa Bay area is Orlando. So, okay. So, there's been a lot going on, and this is actually new from the last time I did this presentation. There's been a lot of pauses and bans, and so we just kind of wanted to give you general overview that as of January 1st, they are now pausing all benefits for people was from certain countries. So before it was like, maybe like an asylum petition that was paused, but now they have expanded it to all pending benefit applications, regardless of when the person entered the United States, because there was also, some dates. And then not only that, but remember, USCIS is the application center. They are going to supposedly re-review approved benefits from anyone that was approved on or after January 20th, 2021, which is when the last administration took office. So the immigration system for applications is so backlogged already. I don't understand how they're going to review benefits that were approved for the last 4 years. But it's certain countries. The ones in bold were the ones that were recently added. But this is impacting, like I said, also like if you have a client from Venezuela who got married and is waiting on their green card, paused. If you have a client, when this happened, a lot of people were actually approved for their citizenship and were literally walking in to their citizenship ceremony and were pulled from the line and said, no, we can't naturalize you. So just keep in mind that these pauses are happening. We don't know, they're supposed to re-review in 90 days, but what happened from the last pause is just expanded it and added more countries. So we just are in a holding pattern. I am still advising people that if they qualify for a benefit to apply for it, because you don't want to like not apply and then waste all that time in the queue, basically. There are some exceptions. There was a lot, so I just kind of put the ones that I thought were more important. I linked the policy memo, but like if you already have a green card and you're renewing that green card, that should be okay. If you became a citizen automatically by operation of law, this happens a lot when you're under 18 and your parents become citizens, then those should move forward. Initial first time application for asylum applications, for work permits, for people with asylum, but not renewals, right? Also, if you have a marriage-based case and you apply for a work permit while that case was pending, that's also paused. And there's obviously an exception to, for athletes, coaches, whatever, we have the World Cup and the Olympics coming. So, we need to have some exceptions for those people, because if not, we won't have games. And then there's a very, very recent pause from the Department of State. So remember, USCIS is dealing with the applications here, people that are here that are applying for some kind of benefit. And now this one, and that pertains to all benefits. And then this pause is by the Department of State for immigrant visas. So immigrant visas are, let's say we have a client who's a US citizen who applied for his minor son from Cameroon. And now that minor son cannot come because that immigrant visa, we're trying to immigrate that child into the US, is now blocked, paused, whatever, banned, whatever term you want to use, effective January 21st. He had his interview like January 18th, and then they asked us for a DNA. And so he's not going to be approved in time, right? So, these countries I listed, and what they're saying for this pause is that they're saying for the other pause, it was like these countries have like oh my God, like security issues, right? Like you can't trust their documents that are not. What this pause with the Department of State is they're really focused on this whole public charge that we think people from these countries are going to come here and like use all our benefits. So that's their, I think, reason for doing this pause. So interestingly enough, it doesn't affect non-immigrant visas. So if you have like a tourist visa and you're from Cameroon, you can come in, no problem. So just something to keep in mind that these pauses are happening pretty constantly. So as immigration attorneys, it's really hard to advise people as to how long a case is going to take because we don't know if a pause is coming next week. Another exemption from this pause is if you're a dual national of a country that is not listed, then you're not subject to that ban. If you already had, so like if my client from Cameroon had already had the visa in his passport, then we are seeing that they are allowing those people to come in. They're just not issuing new immigrant visas effective January 21st from anybody from these countries. And then just quickly, so the U visa is the visa that exists because immigrants were not calling the police, right? And the U visa is for victims of crimes, not all crime. There's a list. It's not like somebody stole my bicycle. It's more like kidnapping, domestic violence. Things are a little definitely more serious. And what's happening is that there was a lot of TikTok things going around saying that there's no more U visas, there's no more U visas. And what's happening is like, no, the U visa still exists. Obviously, Congress is the only one that could take it away. But the U visa, having a pending U visa, not approved, pending, is not the protection it used to be. Before, they weren't enforcement the priority if you had a U visa pending, specifically if you had what was called a deferred action notice. Basically, immigration got to your case and said everything looks good, but we just can't approve it, so they gave you deferred action. So just something to keep in mind that the U visa exists, but it is not a protection from being placed into deportation. Because remember, like we talked about in the beginning, everybody is a priority, and that includes people with a pending U visa or T visa, which is for victims of trafficking. They don't care. They're putting all those people into deportation proceedings. If they already had a deportation order, which you could still apply for a U visa or a T visa with a deportation order, they're just deporting them. Like I had a client last year that was deporting, like from one day to the next, he was gone. The good thing about the U visa is that they can still apply for it from abroad. But just something to keep in mind, because a lot of people think that the U visa doesn't exist anymore. It's just, it does. It's just not a protection from anything. Also, like, just so you know, the U visas, like, there's only 10,000 that can be approved a year, and there's currently 200,000 people in line for a U visa. So it's a 20-year wait. Just wrap your mind around that. Okay, same thing with DACA. DACA, there was a lot of back and forth as to whether the Obama administration had the authority to come up with DACA. So DACA is a type of deferred action. Deferred action is something that has existed in our immigration laws forever. Like one of the Beatles had it for a while. So there's been a lot of lawsuits up, down, here, left, whatever. And then so DACA, as of today, still exists. Individuals that have DACA should continue to renew their DACA. They are allowing first-time applicants to apply, but I have one now that's been pending since the last Trump administration. So they're not approving them. They're just like sitting there. And I think that applying for something right now, which you don't know if it's going to be approved or not, is a little risky, or actually very risky. So I have not filed one since that client that I have sitting there. Also, if you have DACA, if you have a client that has DACA and they have not traveled abroad, I think they should talk to an attorney. It's still a possibility. It's riskier, but traveling abroad with DACA might give that person a legal entry that might open up other doors for them. Let's say they're married to a citizen, but they should really talk to an attorney before they decide to travel. Make sure they don't have a deportation order they don't know about. Make sure that that travel is really going to give them benefit. And also they just need to explore the other legal options. Like I had a lot of, it's not as common now, but before there was a lot of kids that just applied for DACA that could have maybe applied for a juvenile visa, but never did it because they thought DACA was enough. So DACA is temporary. It's just a type of deferred action, which is basically immigration saying, we know you're here. You're just not a priority for enforcement. Here's a work permit. That's all a deferred action is. It's not a legal status of any kind, but it's all that we can give these poor kids since the DREAM Act doesn't pass. And then just a couple of things for regarding work permits, and I'm going to try to go as quickly because we have a lot to cover. If you had a client that applied for, so you had a client with a work permit and they applied to renew that work permit, most, not all, like DACA is not one of them, but most, like if you had a green card pending and you were renewing that work permit, the receipt for the renewal of that permit used to be an automatic 540-day extension of that work permit. And the reason they did that is because work permits take a while to be approved and they didn't want anybody to be without work. And unfortunately, as of October, that was completely eliminated. So now when you go renew your work permit, if your new work permit has not arrived in time of your old one expiring, then you're no longer eligible to work. You don't have anything to show that you're eligible to work. So just something to keep in mind that these I think people got kind of comfortable like applying to renew their work permit like a couple months before it expired because they knew they were going to get this auto extension, but that is no more. There are certain exceptions like TPS by regulations is auto extended, and like the STEM OPT, which for people that are here on like student visas that go work after they graduate. So there are exceptions, but for the most part, there's no more auto extension for work permits. So just something to keep in mind that I am applying for my renewal of my work permits. Like you're supposed to do it by 6 months before. Like that's as early as they say you're supposed to, but I'm doing it like a year before because they are not approving them within 6 months. So. And then another thing that they did before to allow people is like, okay, if we're not approving the work permits quick enough and we're having to give these people these extensions, why don't we just make the work permits valid for longer, right? That just makes sense. We want these people to work, we want them to do taxes. So a lot of work permits, not all of them, were extended for 5 years. So like if you had a pending green card, you got a 5-year work permit. If you had asylum, you had whether granted or pending, you got a 5-year work permit. And it just kind of helped with the backlog of how long work permits were being taken to be adjudicated because we didn't have this need to continue to apply. But as of December, that was totally taken away. And what sucks is that it applies to people that have pending benefits, filed on or after like December 5th. So like they only gave us like a day to make this, valid. So just so you know, like if like I had a client who he got like I filed husband and wife at the exact same time. They're each doing their green cards individually differently. Husband got the 5-year card because his work permit got approved right away. But I had to have the conversation with wife because we haven't gotten hers yet. Like she's only going to get 18 months. So it's really kind of hard to advise clients like that's not fair. And I'm like, I know, but like that's just a change that happened. And then some of them are even going to be less. So people admitted with TPS or parole. There's a lot of them that are only even going to be valid for 1 year. So think about it. You apply for the work permit, you get it valid for 1 year. And then like almost immediately you have to file for a renewal because you don't have enough time if you're not getting the auto extension. So just something to keep in mind that it's just more money these poor people have to pay in addition to, and Marisol is going to cover it. We now have these HR1 fees that have increased the filing fees for a lot of these things. And then just quickly, there is a new photo requirement. So if you were like, why am I getting all these, we call them biometrics notice, where people have to go get fingerprinted and photographed, is because in December, there was a new guidance that now effective immediately for benefits that are filed on or after. This one is for benefits filed, not pending. So that's good. You have to come redo your photo every 3 years. And so I have seen like my clients. And then of when you last took a photo for immigration, if you're applying for like renew your green card or citizenship or your actual green card application, those require a photograph regardless of how long you last took a photo. So there might be somebody that got a green card through marriage and now is renewing that green card. Even if the green card was whatever, like they have to go get a new photo because they're filing an application to replace that green card. So it just so you know, which causes more backlogs because now people have to go to the application center to get photographed and fingerprinted. Okay, I think that's you, Maris.
Yeah. So the pretermission of legal insufficient asylum applications. This is something that just started to happen. We saw a little bit of this during the previous Trump administration, where some judges were basically not allowing asylum applicants to go forward with their cases and prove, whether the cases were legally and sufficient and factually also determining whether there was credibility, because those are issues of fact, not of law. The regulations are still the same, and there is a requirement for there to be an actual hearing to resolve factual issues in dispute, as we see under CFR 1240.11C3. However, There's a case that just came out in 2025. It was matter of HAAV, where basically it says that you have to view all of these facts in the most favorable light of the respondent. Any allegations of in cases of asylum, of withholding or removal or protection against torture, which are forms of relief before the immigration judge, you still have to establish a prima facie eligibility for this protection, and that the judge has to look at the facts in the most favorable light to the applicant. However, the judge may, and here's the kicker, the judge still may pre-terminate the application without a full evidentiary hearing on the merits. The reason they base this new policy memo allowing judges to pre-terminate asylum applications because of what they are calling legally insufficient applications. They base this policy memo on an existing case called Matter of Fefe. Matter of Fefe, however, does not say this. Matter of Fefe, if you read Matter of Fefe, the EOIR's interpretation, Matter of Fefe, is incorrect. Fefe does mandate oral testimony under oath in asylum cases to emphasize that the testimony is essential to determine credibility and factual discrepancies. So not only do the judge is required by statute, by regulation, and by law to apply the law and then evaluate credibility and determine, in favor of the applicant or in favor of the government when there are factual discrepancies. It requires that evidentiary hearing. What the government is saying is basically that there was another case that I'm trying to figure out. There's another case, matter of EFHL, that was vacated based on other grounds. It was vacated because of a definition of what was particular social. What the definitions of what was a particular social group, and what the government is basically saying, no, in this case, basically allows us to pre-terminate these asylum applications if the judge determines that there is no dispute of law or fact. Okay, so there are a lot of motions to object to pre-terminations out there. We're using them, and we can probably I can make them available to you. There's been ILRC and Clinic and other organizations that are putting these templates for motions to object for pre-termination, because obviously it is basically throwing out a case of people that may otherwise for years been able to pursue this form of relief, which is very important, as you all know, because people fleeing their countries and seeking protection in the United States is protected under our laws. So I believe, you're going to see a lot of the stuff. We're seeing a lot of these, the government making a lot of motions to pre-terminate cases right at the onset in master calendars. And like I said, most judges are giving you time to respond. And there are very good templates out there to respond for motions to the government's motion to pre-terminate cases based on this misapplication of matter of Fefe and matter of EFHL. The next issue I wanted to cover was safe third country agreements and asylum cooperative agreements. We've been hearing a lot on the news about people being deported to third countries without any kind of due process. This is part of this administration's enforcement agenda. They want to, obviously, they've increased detention beds and trying to fast-pace removal proceedings. So these agreements existed. Some existed prior to this administration taking over. However, there were a lot of procedural safety issues that were taken into consideration. Just to explain a little bit what these are, the safe third country agreements, have been in place for a long time, and it required, these countries to agree with the United States that they would take on some of our people that we could not be removed to their country of origin for whatever reason, but there were certain safety assurances that those third countries would provide. And the asylum cooperative agreements have been also in place since I believe it's 2019. Correct me if I'm wrong, Adriana. They've been doing, but in this case, this administration has expanded those and is actually entering into agreements with countries that are not agreeing to provide for this safeguards, to provide for the protection of these individuals that are being removed. There's a couple of cases that are pending in federal court that are basically fighting these third country removals, and basically fighting the also pretermission as well.
Did you want to move on?
I'm sorry?
And I was just wondering, did you want to move on or?
Yes. The HR 1 fees, we're talking about, Adriana was mentioning before that during the big, beautiful bill that was passed back on July 4th of 2025, in addition to expanding the money allotted to enforcement, to USCIS, to ICE specifically, there were all these new charges that were added to what we already had, which were USCIS regulatory fees. USCIS, as Adriana explained, is a part of Department of Homeland Security that processes and grants immigration benefits to certain people, applications for family petitions and certain types of applications. And there were already regulatory fees that we'll tell you where you can find them. There was a fee schedule that we followed. The big, beautiful bill created these new HR1 fees that go on to obviously fund different parts of the Department of Homeland Security. And these HR1 fees are in addition to already regulatory fees. And one of the things that was that they said was that basically if there is any kind of discrepancy between a regulatory fee and an HR fee, the HR1 fee, the HR1 fee has precedence. So to give you an example, what that means, for example, an asylum application used to be a free application. There was no fee to an asylum application. HR1 added a $100 asylum application fee that has to be paid every year for asylum applicants, whether it's an affirmative asylum or an asylum before the immigration judge. And like that, there's a number of other ones. I mean, we had forms of relief like cancellation of removal in immigration proceedings. Those were, I can't remember what the regulatory fee was. 110. And now that same application is, the fees have obviously gone up for USCIS, but the HR1 fee is an additional $1,400. So basically, there are no fee waivers. That was one of the things. I mean, there are fee waivers, for example, for EOIR applications, but the understanding that we have is that they are going to be used very sparingly. They don't believe that anybody, for example, who has access to private counsel should be given a fee waiver regardless of their economic condition. In the past, we could show based on need, based on the number of people in a family, whether there were any special situations, a medical condition or something, you could actually apply for a fee waiver before the USCIS, in addition to the immigration judge in addition to EOIR. Now they're basically saying there are fee waivers available. There's a form that is called EOIR 26A. However, based on their own policy memos, they're basically saying, we want to be mindful of fraud, misrepresentation, and these people have been here all these years, so why couldn't they actually pay these fees? Mind you, these fees have tripled. I mean, cancellation or removal and all these other fees, they've exponentially become harder for families to pay these fees, but they don't really care. And so now you have to watch, for example, adjustment of status. There was a $1,500 fee on top of the $1,400 fee that you have to pay to USCIS. So you have an HR1 fee in addition to a USCIS fee. For appeals, for motions to reopen, like I explained before, it used to be 110. Now you're talking about 145 plus a $900 HR1 fee. So this is confusing. We understand this is confusing. There are a couple of, I think Adriana has linked a number of put a number of links for you so that you can go and check out what the fees are, the HR1 and USCIS fee. You also have to be very mindful that now there are two separate fees. They have to be paid separately. And also the other thing that has changed since, I believe, October 25th of this year is that we used to be able to pay those fees in person. There were some, for example, you could pay for a motion to reopen. You would go to your local USCIS office, make an appointment, and pay that fee through a money order or a check. And then you would show the government that you had paid that fee. You would attach that to your motion to reopen a case, for example. Now, all of these fees have to be paid in this EOIR payment portal, including HR1. But as I said before, you have to pay them separately and show the receipts for both separate payments. So you have a USCIS payment in addition to an HR1 fee payment.
I did want to clarify something because I was looking at the EYR portal and it looks like now, like for the green card applications, they are combining them as one fee on the EYR portal. So that's good because if not, like, Marisol was saying, you would have to make one payment one place and then another payment. But it looks like they finally figured out the EYR portal. But just think about it, if you're applying for a green card with USCIS, it's $1,400. But if you're in court, it's $1,400 plus $1,500. And that's per person. So it's almost $3,000. So in a family of 5, we're talking about almost $15,000 in fees. And so in court, you can get a fee waiver, although if you do, they're going to assume it's fraud because you can pay a private attorney. So therefore you shouldn't be eligible for a fee waiver. But in Immigration Service Center, no fee waivers. So it doesn't really make sense.
Yeah. And when this started, when they implemented this back in October of last year, there was a lot of confusion. EOIR wasn't talking to USCIS, and there was, even with the $100 asylum application fee, there were a lot of misunderstandings as to who had to pay those fees. There were some dates where people had to pay the fee right away, depending on when you had filed for that benefit, and there were people who could wait until the following year. So there's a lot of confusion and not very much cooperation between those agencies in clarifying this for the public at large. It seems that they gotten their act together a little bit now, that they are actually in sync. The other thing that's important to note, as I said before, they don't take checks, they don't take money orders. You can pay USCIS fees. There's 2 forms you have to use. One is a G1650 for ACH authorizations, payment through a bank account. You put all your bank account information and it's an automatic deduction. And those have been working really well in my practice. I don't know about Adriana. We've done like a lot of 601A waivers and things like that through that. And you get a receipt. They're doing this, pretty routinely now. You can also use a debit card, and it's a different form that you have to use for a debit card payment. It's a G1450. And you can use prepaid Visa cards, credit cards. They don't have a lot of my clients don't have credit cards, don't have debit cards, but this is a way that they can go to Walgreens or whatever, get a prepaid card and pay for these fees. And again, always look at whether there's always going to be a USCIS fee and a regulatory HR1 fee. I mean, the regulatory, fee in addition to the HR1 fee. So there's most likely going to be two types of fees that your clients are going to have to pay.
Awesome. And it's one form. So if you have a credit card authorization and you have like a green card application and a work permit application and a travel permit application and a petition, it's one form one credit card authorization form per form, and then one form per type of payment. So if there's an HR, so you can have like 7 different credit card. So it's immigration trying to ding your credit card 7 times. So you have to make sure your clients call their banks to authorize these crazy payments coming through all at once. If not, the entire case will be rejected.
Yes, and that's very important. I'm sorry, I forgot to mention it is a form per application. So again, if you're doing an adjustment application and you have, employment authorization, an I-45, maybe an advanced travel document, and you're doing multiple. You're having to fill out multiple forms, one for each application. So. Matter of Yahudi Hurtado, we thought this was important to bring up here because as I was trying to explain before, I mean, the government, this administration has expanded who is eligible to be detained, and who also, most importantly, would be eligible to bond out. Under this case, the matter of Yahudi Hurtado, the BIA reinterpreted who was eligible for bond, who was a person who had entered without inspection. The judge always in the past had the power to grant bond under to INA 236A if the person wasn't a danger to the community, did not have a criminal record, and have a community that supported them, employment, etc. When we used to do these motions to request bond, that's basically what we would argue to the judge, and 9 times out of 10, your client would bond out, unless there was a disqualifying factor like a serious criminal offense, or they were inadmissible based on other issues. But an IWI person with a form of relief available would be able to bond out of detention. In this new era that we're living in, and because of specifically this BIA case that was basically published back in June of 2025, the immigration judges were under strict orders to strictly enforce Yahudi Hurtado. And so we saw a significant decline in people who were bond eligible. Right now, the only people who are bond eligible are people who have been admitted, inspected, paroled into the United States, nobody else. And what that has done, obviously, with the increase in enforcement and detention beds, you can see where this is going. Basically, this has encouraged and facilitated this administration's enforcement priorities. And so now, I don't know about Adriana, I can tell you about my cases. I had a gentleman, for example, who is married to a U.S. citizen, has an I-130 pending, has been here since 2000, has significant equities and ties to the community, no criminal record whatsoever. He goes to check in because he had a cancellation of removal pending, a non-LPR cancellation. He wasn't detained, obviously, and he's been complying with every instruction possible. He goes to check in his what we call OSAP check-in, and he gets detained prior to Christmas. And now basically moved all around the country. And we're trying to file what we're calling, we're trying to file a habeas, which I'll talk a little bit about it. But why is this important? It's important because many of your clients, as Adriana said before, that we didn't think were enforcement priorities before, U visa applicants, U visas with deferred action, and DACAs with deferred action, people who held temporary protective status. It's not what it used to be, but it's still there were not enforcement priorities. People who had a marriage case that was pending before USCIS that were just, normally we never would have worried about somebody getting picked up at an interview process. Now all of those people are subject to detention under these rules, although I guess someone who had been, except for people who have been inspected or paroled. And what we're seeing right now is an increasing need for people to file habeas corpus petitions before federal district courts. And uniformly, federal district courts are agreeing with our interpretation and advocates' interpretation that the government's interpretation of new interpretation that these people are not eligible for bond, that's incorrect. And federal court after federal court is ordering immigration judges to have bond hearings and allow these kinds of cases to post bond. But the recent thing, and there is this case that we mentioned here, Maldonado Bautista, was a federal district court in the middle district of California, who basically issued an order saying, as of last December, that matter of Yahudi Hurtados who should not be followed. This judge created a class action that addressed specifically this factual issue, and she said matter of Yahudi Hurtado is no longer valid and that immigration judges should not follow. As recent as I think last week, we saw some leaks, and the chief EOIR Chief Justice coming out and saying that Yahudi Hurtado is still good law and ordering judges under EOIR to follow Yahudi Hurtado, despite the fact that Maldonado Bautista and the judge's order in Maldonado Bautista that this is a class action and that Yahudi Hurtado is not to be followed. So again, if anybody out there wants to engage in assisting us at some point in putting together habeas cases, this is going to probably be where most of us are going to be practicing in immigration court in the near future, because as I said, a lot of these judges are violating the law. Immigration judges are violating the law and refusing to follow federal court orders. So, and that is the importance of this particular case and the Maldonado Bautista class that I was discussing.
Thank you. One of the things that I think it's also shocking to some people that do not practice immigration law is that, as Marisol mentioned, our they respond to our Attorney General, right? So our Board of Immigration Appeals, which is where all these cases come out of, the BIA, if our Attorney General does not agree with a decision that the Board of Immigration Appeal has decided, they can redecide the case. So we have seen a flurry of cases that have been redecided in the last year. And this happens every administration. So just kind of wrap your mind around that, right? That we have the Attorney General just picking cases and redeciding them. And that's what happened with this case.
And also, and I don't know, I forgot to mention this, Adriana, I'm sorry.
No,
because they work for the Attorney General, another thing that we've seen is that over 100 immigration judges were fired on the spot, literally in the middle of proceedings, just told you no longer work for us, just because EOIR and the Attorney General did not agree with how they were issuing decisions. And obviously that goes to the independence of this immigration judge office. They're not independent at all, and they have to follow the Attorney General's decision. If the Attorney General doesn't like a decision, they issue their own. So there is no independence when it comes to the immigration judge, which is why we are resorting to federal courts and federal district judges to help us obtain some, to try to protect due process for our clients.
All right. So we only have 15 minutes. So I'm just going to generally discuss kind of what's going on with citizenship, just to give some time for questions. So a new memo came out in August, basically redefining this whole good moral character and what it means to apply for naturalization. So before, you've always had to show good moral character, which usually means like if your client got arrested in the 5 years before applying for citizenship, depending on the arrest, they're likely not going to be able to apply for citizenship until they're done, at least in the Tampa Bay area. It's 5 years from the date they finish probation. And then that's what begins their good moral character. So usually if some crimes make you ineligible, but if the crimes were like a DUI or something that you could still apply for citizenship, and the DUI was more than 5 years ago, and you've done your taxes, and even if you owe taxes, if you show that you've been paying them, if you don't owe any child support, then you were usually fine with applying for citizenship. But now they're starting this whole they can't just look at the non-existence of negative factors. They also have to look at these, positive factors. And, we personally in my office have not submitted anything to show positive factors because I feel like a lot of it is already in the form. Like they want to show that you've been working. Well, the form asks that. They want to show if you're a member of any organization. Well, the form asks that. I'm not giving immigration more information than is needed. And so far it's been working. We'll see how it works. We have noticed a shift with taxes, that they really want you to see that the taxes are paid, and payment plans have been an issue lately, but it's kind of hit or miss too, depending on the officer you get. So I would always come prepared with 5 years worth of taxes when I walk into a citizenship interview, just in case an officer wants to see them. If they have children and they don't live with that children, you better be able to show that they're, paying child support. But just kind of something to keep in mind, that it's not just like, okay, you've been doing good. Like you kind of have to show more now, according to them. But so far, I don't feel like this has been as bad as we expected so far. I don't know what 3 months, but that's going to be. And then one of the new things that I haven't seen it in the Tampa Bay. I think I've only heard one in the Tampa Bay personally, but they're starting these neighborhood checks for people that are applying for citizenship. They already, did it. They're doing it more now for people applying for a marriage-based green card. They would come around asking your neighbors like, hey, what do you know about the couple that lives there and stuff like that. But now they're expanded it to citizenship, these neighborhood investigations where they're going to come around, asking your neighbors to see, if you, I guess, are a good person to do citizenship, which is just all sorts of problems. Because what if you don't get along with your neighbor, right? So just something to keep in mind, that people that are applying for these benefits need to understand they're going to be under a lot more scrutiny now than they were before. They're also really heavily looking at previously filed applications. So we got a call from somebody who got his green card, I'm not kidding you, 25 years ago, passed his citizenship exam. He was walking into the ceremony. He got pulled aside and they started asking questions about his co-sponsor. So when you apply for a marriage-based green card, you need your spouse is supposed to be your sponsor, saying that they're going to keep you at the poverty guidelines, basically, for a certain amount of time. Well, this person used a co-sponsor because the wife didn't make enough. And then they started asking questions like, did you know that this person's taxes were wrong? And this was 25 years ago. He was like, I have no idea what these people were talking about. So they're really digging deep in prior applications. So anytime that somebody walks in to do a citizenship, whose case I have not touched before, I'm like, I need to see all your previous filings because I need to make sure everything was done correctly. Because if not, they're just going to put you into deportation proceedings. Another citizenship thing is you have to be very careful with your clients with what we call false claims to citizenship. And this is, believe it or not, most people do it unintentionally. For instance, perfect example, DMV was auto-registering everybody to vote that applied for a driver's license. Registering to vote is claiming you are a US citizen. So it's causing a lot of problems, and we would have to show the registration thing and how my client didn't sign it, and it was just a checkbox that the DMV person said, and go back and if you were able to get a letter from the DMV place. This is a big problem when clients are going around and I've been, every time I go to a place that there's a voter registration table, I stop and I say, hi, I would just like to make sure you understand that only US citizens can register to vote. And you'd be shocked at the amount of like answers I get. What are you talking about? If they have a green card, they can register to vote. And I'm like hyperventilating, right? Because this is my clients think that they're doing, these people who look official telling to register to vote, they're going to do it because they want to do right? They want to be good citizens. And it's going to destroy their eligibility to do their citizenship in the future. Before you can show like they didn't know, whatever, but now I would not file, even if I have an argument to say my client had no idea, I would not file anybody right now that was on the voter registry before. Because before you can like deregister them, show that they didn't do this, like, you had arguments, but like right now, absolutely not. They will be automatically put into deportation proceedings. It's just a risk I would not take. And then there's a new naturalization test. They just expanded the number of questions to 128 from 100. This is for people that filed on or after October 20th of last year. So if you had an application that was filed before this, you still take your test with the old test, regardless if it was pending at that time. And then you have to get 12 out of 20 correct, as opposed to 6 out of 10, how it used to be. The questions are online. Interestingly enough, the 128 questions are still, well, I guess the extra 28 questions are still not available in Spanish. So you have to go to another nonprofit that has translated them, because USCIS has not done that. Because some people can't take the citizenship test in Spanish. But just something to keep in mind. I do think that next up is a rehash of the citizenship test to make it more difficult. So if somebody can apply, I would highly recommend that they do so now. Another thing that I saw is that when you apply for citizenship, you can request a lower fee in your application. And there were some people having issues with the officer questioning like whether they were like a public charge for citizenship, because they had requested a cheaper like a fee for filing fee, which is just something to keep in mind, that like it's just a mess right now for that. So some Florida specific things really quickly. Before, if you had like one of those 5-year work permits, you would get a 5-year driver's license, but now your driver's license is for 1 year, regardless of what your work permit says. Obviously, this doesn't apply for people with green cards. People with green cards get like, just like anybody else, like a US citizen. I don't know, I think it's 7 years in Florida now, but just something to know, because I know some clients, sometimes they lose their driver's license and they've been used to getting for years, and now it has to be renewed every year. Some good news that in Florida, we have this huge issue with notaries and immigration law. They basically practice law without a license, and a lot of our clients trust them because notaries are attorneys in their home country. And now they're supposed to visibly put that they're not an attorney, and they can't practice law, and they can't give legal advice and things like that. So, hopefully this will help some clients understand. And then Florida was trying to pass a law that made it a crime to enter the state while being undocumented. And thankfully that was blocked, although our attorney general was saying that we couldn't follow it, but now it seems like we are following it. So I don't know, Marisol, you guys were I don't know if you have any input as to that.
So my organization, Americans for Immigrant Justice, and our fabulous litigation and advocacy team were the ones that actually teamed up with the ACLU to file suit against the state of Florida. And yes, it has been blocked. And actually, because of our attorney general telling his Florida Highway Patrol people that they didn't need to listen to the federal district judge, he was held in contempt. Yeah. Which has created quite a bit of a stir. But yes, I mean, this is basically it should not. They're not able to use this to stop people across the border and charge people with trafficking, even if they had a family member in their car and one member of their family was undocumented, which is one of some of the very draconian provisions in this law, was giving Florida legal authority to prosecute people that were, going across state lines just because of, with family members. So it's blocked for now. I think it was found that a lot of the provisions were not constitutional, and as far as I know, that's still the case. It's not enforceable.
Perfect. And then just quickly, clinic just came out this week with a summary of all the policy changes, because I know it was a lot, and I think they did a great job summarizing it. It's not a super long read, and I think it's helpful for people to understand some of the policy changes and how it's impacting our communities. And then just if you have clients, obviously AI Justice is amazing. They have these free consults Tuesdays and Thursdays, so I just wanted to put that up there. And if family members, community members are having a hard time finding their friends and family, there's a hotline that they can call, and they will kind of try to triage the situation to help them out. All right. Okay. So that gives us about 5 minutes to go through some questions. I'm going to see.
So we have a lot of questions in the Q&A, but before we officially start the questions and wrap up, I just wanted to take a moment to thank both of you for an amazing presentation and everybody that joined us today. And it's sharing your expertise with this type of topic, how everything has changed in the last year. This is a very much needed topic. I also wanted to take the opportunity to thank the Public Interest Law section, in particular the Civil Rights and Immigration Work Group. I know DJ is here because I saw him in the chat earlier. Leah, thank you as well, Leah Burnett, for putting all this together and connecting me with Adriana and Marisol. And a quick reminder with the CLE details, I dropped them in the chat again. The CLE code is 2517924N. And I have to do one quick plug for a webinar that we have next week on human trafficking cases that impact children. I dropped the registration link in the chat. If you didn't know, it's Human Trafficking Awareness Month, so it's kind of a great way to wrap up the month. So if anybody's interested in learning more about those topics, make sure to register. So with that said, I want to make sure that we have time for questions. If we go over 1:30, at least for me on my end, it's totally okay. Adriana and Marisol, if you need to jump off, let me know. But what I'll do is, in case we want to be very candid and allow people to ask questions, I'm going to stop the recording right now. And that way we can open it up. I think people can raise their hands if they want to come up, and I can bring them off mute if it makes it a little bit easier. So with that said, for the recording, thank you everybody for joining us, and I'm going to stop it.